Okay, any questions? No? Okay, let's move on. We have just talked about common mistake, right? Here we have mutual mistake, mutual. Now, don't mix it up. In practice, we often say mutual agreement, right? Have you heard about term mutual agreement? Right? Yes, okay. Mutual agreement usually say, oh, we have all of us, two of us, right? We both agree. Then we mutually agree, right? But here is different. Mutual mistake. When it comes to mistake, this term means mutual, means what? Each party misunderstands the other's intention. That means they do not make the same mistake mutually, but they both make a mistake, but that mistake is different, right? So this is said to be cross purposes between the parties, party A and B. Then if you just look at these two bullet points again, it seems not that straightforward to be able to understand, right? So that's why we have to read precedents. The Raffles case, the parties agreed to sell and buy a consignment of cotton cargo. Okay, cotton cargo, assuming we have this picture in mind, cotton cargo. Due to arrive experienced from Bombay, in fact, I briefly mentioned this term, these precedents before, peerless. So what was it? Now, again, unknown to the parties, there were in fact two ships, but having the same name. This ship is called Peerless. This one also Peerless. Okay, but unknown to both of them. Okay, the two parties were not aware that there were two ships having the same name. Okay. Then the seller thought that the contract was for the December cargo, while the buyer had the October cargo in mind, because what one ship was sailing in October, the other in December. They are carrying different cargoes. Okay. So the buyer was entitled not to accept the December cargo because what? That was a mutual mistake. The two parties have something in mind, but that thing in mind in A and B are different. That is cross purposes. Understand? Okay. Okay, the third type of mistake, unilateral. Unilateral. This one easier to understand, I hope. Unilateral meaning one-sided, one way. Uni, okay, one-sided, one way. Okay, one party makes a fundamental mistake to the knowledge of the other. Now, there's a condition that the other party knows about it. So now we have two parties, A and B. Say A made a mistake. At the same time, B knows that A made a mistake. Okay, two parties, A made a mistake, and B knows that A made a mistake. It is this statement. Okay. Then I think in your mind, you want to have an example to help you understand, right? Now, before that, this kind of mistake often involves manipulation or fraud. Manipulation or fraud by one party. Okay. For a unilateral mistake to be operative, the other party must have known or ought reasonably to have known the mistake. Again, these are just statements to explain the idea. It's good, it's better to refer to a precedent. Then you should be able to understand it easily. Okay, in the Webster's case, the defendant, D, okay, had already refused to sell his land at this price, 2,000 pounds. D already refused. That means what? D would like it to be at a higher price, right? £2,000, not good enough. D would like it to be sold at a higher price. Okay. Otherwise, he would not have refused to sell it at this price. Okay. Subsequently, D wrote to the plaintiff and offered to sell it at 1,250. So D already refused to sell it at 2,000. How come D would write to P saying, okay, I would like to sell it at 1,200? It must be a mistake, right? So that is even cheaper than the original refusal price? No way, right? Should be a mistake. So perhaps, okay, D intended to write 2,250 instead of 1,250. It's more reasonable, right? Because originally D refused to sell it 2,000, so would like it to be at a higher price. Maybe he like it to be at 2,250. But unfortunately, he wrote it wrong, 1,250. That must be a mistake, okay? So the plaintiff P on the other side promptly accepted, right? Promptly accepted the offer. Okay, he wrote 1,250. Okay, I accept. So I just need to pay 1,250, right? So defendant realized that he had made an error and gave the plaintiff notice of it. But the plaintiff sought to enforce the contract because it is cheap. Plaintiff knows that, oh, he can get benefit for such a low price, okay? Specific performance reviews, as the plaintiff knew or ought to have known of the mistake. As I said, the plaintiff should have known that this was written mistakenly. Should not be 1,250. Should not be that cheap. Right? Understand? Okay. So this refers to unilateral mistake. One party makes a mistake to the knowledge of the other. And there are further types of mistakes. As to signed documents, mistake as to signed document. Not a mistake about the subject matter. Okay. Now, in this case, right, so it is about the subject matter, the price of the subject matter. And in this case, it is about the ship carrying the cargo, right? But here is a mistake as to the signed document, not about the subject matter, but mistake in signing the contract. Sign the contract mistakenly. So a person who signs a document, as mentioned earlier, who signs it, he is bound to it by it. No matter you claim that you have read it or you have not read it, right? No matter he has read it or have not read it. But there is exception to this rule, doctrine of, again, Latin, okay? It's not ordinary English. So what does it mean? The act of signing is not his deed, is not his will, is not his intention, is not what is in his mind, okay? He just signed it mistakenly, okay? Mistakes as to signed document, mistakes in signing, okay? Not according to his wish. So in order to escape the binding nature of a signature, because as before, we said that no matter you have read it or not, once you sign it, then you are bound by the contract. But there is an exception. And in order to have this exception, one needs to prove the following things. Number one, the document signed was radically different from the one forged to have been signed. Okay, for example, you're signing on a contract, say you imagine or you thought that, oh, it is for a cleaning service. You signed it, okay? But mistakenly, actually that contract is for repair service instead of cleaning. So that is radically different from the one thought to have been signed, right? Cleaning contract, repair contract, very different, okay? Then this is this condition. The signing had not been done negligently, and also need to prove that the signing was not done carelessly, okay, not negligently. And the signer was suffering from a permanent or temporary disability. Permanent or temporary disability, for example, the moment you sign it, your mind was not clear, it was affected by drugs or whatever, medicines maybe, or you are in serious illness, something like that, okay? And another kind of mistakes could be as to identity. Occur when one party is fraudulent and parades as somebody else in order to deceive the other party. Deception, deceive, cheat, like cheating. Okay. Say someone approaches you saying he or she is a superstar, for example, right? But with mask on it, maybe, okay? And pretends to be that superstar, okay? So parades, pretends to be, okay? So the identity of that party is not actually the superstar, okay? So it's a mistake as to identity. The innocent party may claim operating mistake, but he has to prove several things. Number one, his intention was to deal with someone other than the person, other than that person. Number two, the other party knows of his intention. And number three, he has to verify the identity of the other party. He has to diligently check, for example, ask, okay, who are you? Are you actually that superstar? May I have a look at your ID card? This and that, okay? Verify, try his best to verify the identity. And the identity of the other party was important to him in the transaction. So whether that guy is really that superstar is important to the transaction. Okay. Now, for example, the guy approaching you is just a representative of a company, right? And the company can have multiple representatives. Okay. So then the identity of that guy is not important as long as the guy approaching you has the capacity to represent that company, right? But if you are signing a contract with a superstar, say for a concert, for example, okay, so you need that superstar, right? If that guy is parade, right, not actually the superstar, then that is not the party you wish to sign with for that contract. Okay, misrepresentation. It's not actually mistake, but misrepresentation. What does it mean? It is false, not true, or misleading, and it can be made orally or in written form. Okay, made by one party before or when making the contract, not after. Right, not after making the contract, but before or when making contract. Again, it's better to have example, right? So, give an example. If it is about this product, right? In the advertisement, it is shown like this. For example, hamburger. Okay, so you refer to this picture, you are induced by this picture. It looks nice. You go and buy it. But in reality, it is like this. right? Misrepresentation. So it could be, say, pictures, it could be a statement, right, in the contract saying, okay, if you hire me as a contractor, I will provide you excellent service, right, in managing your facilities, right, with a world-class equipment, right, with a team of competent workers, right, with 100 workers serving your site, but actually has only 10 workers, right? So that is misrepresentation. Okay, understand? So this one, looking at this picture, easy to understand, right? And does it happen in our daily life? Right? And sometimes when you go to a restaurant, right, we look at the price list, the menu, right? Sometimes we look at the pictures, pictures appears to be very nice dishes, right? But when the dish arrives and taste it, it could be very different from what you expect. Okay. So in order to claim a misrepresentation, the following must be established. The representation of fact was made, and the representation was really false, really untrue, and it was addressed to the party misled before or when making the contract, not after. Okay, was intended to induce, direct, okay, direct the contract, and direct the other party to sign to enter into the contract, and did actually induce the contract. Okay, in order to claim that there really exists a misrepresentation. All right, apart from mistakes, there are some other vitiating elements in contrast. Duress. Have you heard about this term? Duress. Okay, not durable, not dress, but duress. And undue influence. Okay, what is duress? Coercion, force, or threat of force. Threaten. You threaten somebody, saying, oh, if you don't sign it, I would do something that is not good to you. Something like that. Okay? So coercion, force, or threat of force. A contract made with duress is voidable. It is valid and enforceable until steps are taken to rescind it. Rescind is to cancel. Okay? Make it ineffective. Cancel the contract, like rescind. No duress if a party is under the influence only. Now, influence, undue influence is different from duress. Okay? Duress is with force, threats. Influence, no physical violence or threat of violence. Okay? So it's like these two terms are different, influence and duress. Duress is more serious. And for duress, there are actually 3 types of duress. Okay, here maybe I give you a short video, show you a short video, and you can better understand the meaning of duress and undue influence.
Each party must manifest their assent freely and voluntarily. If one party's assent is coerced or otherwise not freely given, the law will not enforce the contract again.
This is violence, threat. Well, if you don't agree, I'm going to punch your nose. If you don't sign it, I'm going to hurt you. Okay? Duress.
One such coercion is known as duress.
These are the sections in some overseas ordinances. It doesn't matter, right? You don't need to memorize these sections, but just refer to the ideas presented by this video.
Which is dealt with in sections 174, 175, and 176 of the restatement. In general, duress involves instances in which one party uses an impermissible threat to pressure the other to enter into a contract. In such instances, the contract is voidable by the victim. Under older contract law, duress was a defense to enforcement of a contract.
This is even more serious. So if you don't agree, I will kill you. Right? It's a very serious threat.
Only in extreme circumstances. To invoke duress, a party would have to show that the other had induced her into entering the contract by using actual force or an unlawful threat of death or bodily harm. In other words, under older law, one would have to argue that a proverbial gun was held to her head, and as a result, the victim had no choice but to sign the contract. This basis for avoiding a contract is still embodied in the restatement in section 174, which deals with the person's manifesting assent as a result of being physically compelled by duress. In such cases, the party's assent is not effective. Obviously, the occasions on which section 174 operates to void a contract are very rare. More recently, duress has been expanded beyond these narrow parameters. A person can invoke duress to avoid a contract if they can show that their free will was undermined by an unfair pressure, short of physical compulsion, or a threat of bodily injury. In particular, economic duress is now recognized as a basis for relief. This more modern document.
This is one of the three duresses I'm going to explain to you, right? So you can refer to this video to get some preliminary ideas.
Embodied in sections 175 and 176 of the restatement, is better able to accommodate situations where one party uses subtle threats or improper pressure to gain the other's assent to a contract. Subpart 1 of section 175 of the restatement sets forth two requirements for duress. First, a party must show that its assent to a contract was induced by an improper threat. Second, the party must show that, as a result of that threat, he was left with no reasonable alternative but to assent to the contract. If these two requirements are established, then the contract is voidable by the victim. Note that because the contract is voidable and not automatically void, the victim can choose to follow through on its contractual obligations and seek compensation for the perpetrator's wrongful act in other ways, such as in a tort suit. Let's explore the first of the two requirements for proving duress, an improper threat. In general, a threat is an indication of an intent to do something that will inflict harm, loss, or injury on a person's body or their personal or economic interests. The intent does not have to be explicit. It can be implied from the words or the actions of the perpetrator. The threat can be either of a positive action or of a refraining from action. Section 176 of the restatement sets out a number of examples of what makes a threat improper, many of which might be described as instances of extortion or blackmail. For example, subpart 1b states that a threat to institute a criminal proceeding is an improper form of pressure. While someone who has a colorable tort claim against another may threaten to file that action absent the other parties agreeing to a settlement, public policy considers a threat to institute a criminal prosecution to be an improper bargaining chip. Consider a creditor who says to a debtor, "Pay me what you owe me or I'll sue." As a result of this threat, the debtor is induced to enter into a settlement agreement. Under such circumstances, it is unlikely that a court will void the agreement based on duress. The creditor was acting perfectly within her rights. Similarly, if at the end of the term of an employment contract, a very valued employee threatens to quit unless her salary is significantly increased, the employer will not be able to avoid a new employment contract at a higher salary on the basis of duress. Again, the employee is acting fully within her rights. In contrast, if at the end of the term of an employment contract, the employer threatens to make it difficult for the employee to obtain alternative employment unless the employee signs a release of all claims against the employer, that might well be an instance of an improper threat. Assuming there is no basis for the employer to badmouth the employee, if the employer could make good on the threat in the local business community, the employee may well be deemed to have no reasonable alternative but to sign the agreement. Under such circumstances, a court would likely consider the agreement voidable by reason of duress. In general, a bad faith threat to engage in vexatious litigation is an improper threat. A threat to embarrass or do something spiteful to the other party to a contract might also be considered an improper threat. A violation of the duty of good faith and fair dealing under subpart 1D of section 176. Let's now turn to the second element of duress, no reasonable alternative. An improper threat does not amount to duress unless it leaves the victim with no reasonable alternative but to succumb to the threat. In determining whether there is a reasonable alternative, two issues arise. The first relates to the victim's emotional state and whether or not he had the fortitude to stand up to the perpetrator of the threat. Under older law, in determining whether a party was left with no reasonable alternative, courts looked to whether the threat was serious enough to compel a person of ordinary courage to yield to it. Realizing that a bully should not be able to enforce a contract merely because his victim is easily intimidated, modern courts take a more relaxed view and now consider subjective attributes of the victim. The modern test is whether, under the circumstances, the duress substantiates.
That sometimes happen, right? In reality, we may have a big company, right, and a tiny company, right? So the bargaining positions very obviously different.
But to acquiesce. As noted in comment C under section 175, persons of a weak or cowardly nature are the very ones that need protection. The courageous can usually protect themselves. But in addition to considering the emotional fortitude of the victim, there is a second issue that bears on whether the victim had a reasonable alternative. That issue concerns the exigencies in which the victim finds himself. If the victim faces financial ruin or the perpetrator to follow through on the threat, then the court might well conclude that the victim had no reasonable alternative but to succumb to the threat and sign a contract. So let's consider two cases. First, assume that Joan enters into a contract with Bill, whereby Bill will supply 1 million widgets to Joan's factory on January 1st at a cost of $1 per widget. Joan is purchasing the widgets to fulfill a contract with the federal government, a major client, performance of which comes due on January 15th. On December 31st, one day before he's contractually bound to deliver the widgets, Bill calls Joan and states that he refuses to supply the widgets unless Joan signs a new contract, whereby she agrees to pay $2 per widget. If Joan signs a new contract, will she have the defense of duress available to avoid the new agreement? Stated in terms of the doctrine of duress, did Joan have no reasonable alternative but to sign the contract? The answer is, it depends. On the one hand, Joan could walk across the street and purchase the widgets at another factory. It's doubtful that she would have the defense of duress available to avoid Bill's enforcing the new contract.
Okay, now I would like to stop the video here, and if you're interested, I can share the link for you so that you can further view the video later on. Okay. Okay, there are three types of duress. In fact, the video mentioned this one already, economic duress, and also this one, duress to persons. But we also have the second one, duress to goods. So duress to person, simply actual or threatened violence to the person. Okay, so the case you can refer to is the Barton and Armstrong case, threatened to kill, say Armstrong threatened to kill Barton. So if you don't sign it, I will kill you, something like that, okay? So this is the facts of that case. So it was held that the agreement was voidable, okay? And then the second type, duress to goods, threaten of damage to goods. For example, if you don't sell the goods to me, I would damage the goods. So traditionally not recognized by the law, but today it is a ground for relief. Okay, so it is also a kind of duress. The third type, economic duress, is comparatively common nowadays commercial environment, some cases, coercion. But mere hard bargaining is not economic duress. Now, if the two parties are just bargaining, so you want to sell it at 1,000 Hong Kong dollars, I want to have it at 900, right? Then the other parties do not agree, how about 950, right? Then bargain again and again. This is just hard bargaining. It doesn't constitute economic duress, okay? It's not as serious as really a duress. So again, we need to consider the circumstances to decide whether it is really a duress or not duress. So affirmation, in the law of ocean shipping case, the affirmation is a crucial factor to the decision to decide whether it is duress or not duress. So fully aware of the default and of the right to rescind, that's something which indicates a desire to continue. In fact, during the bargaining process, either one of the parties have the choice to leave, right? They may just do not enter into the contract. They have the right to rescind, right? That's something which indicates a desire. But if they continue, decide to keep in the negotiation process and continue, that is the statement here, desire to continue with the contract. So like this case, let you have 1 minute, try to read the facts and decision held. I would explain the case to you. Okay, 1 minute. All right, this is a shipbuilding case. The defendants D will shipbuilders agree to build tanker like this one here for the price of over, well, it's a big sum of money, right? 30 million US, but pay in 5 installments, not in one go, 5 installments. After the first installment, the defendant told D told P, plaintiffs, that additional 10%. So D asked for 10% more. Okay. But unknown to the defendant, the plaintiff had already made a lucrative contract, profitable contract. To charter a tanker and so had little choice but to agree to the demand. So the plaintiff had no choice but to agree under that duress. Tanker was eventually delivered. 8 months later, P claimed the return of that 10%. Was that successful? It was held that the contract, the agreement to pay additional 10% was voidable because there was an economic duress. Okay, because that guy asked for 10% more. Okay, it's a kind of a duress. If you don't pay me 10% more, I won't do it for you. Okay, but at that time, plaintiff have no alternatives to agree. Okay, and however, the plaintiffs failed because what? There was affirmation. Now, the problem is the plaintiff affirmed affirmation of the agreement by them and so lost the right to set aside the contract. Okay, so originally that is voidable. Okay, voidable because that is an economic duress. But the problem is the plaintiff affirmed to the agreement. Okay, other than duress, we have another term called undue influence, misuse of a relationship of trust or confidence between the parties that would make a contract voidable. Not void, but voidable. So innocent party needs to apply to the court to make the contract rescind or rescission of the contract. So if the innocent party does not apply, then the contract can still go on. Okay? But if the innocent party decides to apply to the court to rescind the contract, he or she can do so based on if there is a fact that there was a misuse of a relationship. So illegality and weakness make a contract illegal contract, then of course the contract would not be valid. That must be a vitiating element, right? Illegality, illegal contract will not be enforced by the court. Say if it is a contract for the sale of drugs, for example, okay, that is illegal, right? So there must be a vitiating element. Maybe declare so by an ordinance or maybe so at the common law on grounds of public policy. Some other examples like sexual immorality, right? Say if it is a deal, a contract on this matter, it is of course illegal. And if it is a contract promoting corruption, it is also illegal. Okay. Effects, neither party can force and performance, okay, cannot be recovered, okay, because at the beginning already, this is already an illegal contract. The other term, weakness, whether it is weak or not weak. Terms must be clear. I talk about this again and again, right? In order to allow the contract to be enforced. Vague or ambiguous, something not clear, the terms are not clear, then they may not be enforceable. If you have specified, if you have a clause, a statement in the contract, but that description is not clear, it's vague, then it's not enforceable. Example, precedent, the Scammell case, there was no reasonable, no enforceable contract because the terms was too vague, uncertain, and it required further agreement to be reached between the parties. That clause in that case relating to hire purchase terms. Hire purchase, sometimes we may hire an equipment first. After a certain period, it becomes a purchase agreement. So then the final part here, discharge of contract. What do you mean by discharge? Maybe in practice, people would just think that, okay, there's a contract period. When it comes to the end of the contract, then the contract ends, right? And that is one possibilities of ending a contract or discharging a contract, okay? But there are other possibilities as well. Contracts may come to an end or may be brought to an end by either ways here. For example, by performance, by agreement, and so on. Okay. Even a breach of the contract may lead to the end of a contract. Okay. Why? Is it true? So I'm going to explain these to you one by one. By performance, substantial performance. Performance is legally complete. Performer is entitled to the contract price less the cost of defects. So if you are working in the building industry, you have dealt with building contracts. Maybe you have come across the term practical completion. Have you? Say in constructing this building, if it is 95% complete, for example, okay, it's not 100%. Substantially complete. But there may still be some defects, in a construction project. It's very often that we still have defects, even when a building is occupied, okay? We allow some time for the contractor to rectify the defects. In that case, the performance under the contract is already substantial, largely complete, okay? Then that could bring an end to the contract. The remaining part is just for making good the defects or any other minor omissions, okay? Precedent, you may cite this case to support. Severable contracts, severable. It comes from the word sever, not seven, not several, but sever, S-E-V-E-R, sever. Sever meaning cut it, part by part, okay? So if a large contract comprises a series of smaller contracts, payment could be claimed on a quantum merit basis. Again, this is not an ordinary English, italics, Latin, okay? Meaning as much as he has earned for the work actually delivered, okay? So we have a big contract. We may have a contract for, say, constructing a building phase by phase, phase 1, phase 2, phase 3, phase 4, okay? Then phase 1 may be a smaller contract, phase 2 also a smaller contract if you compare to the entire development. Series of smaller ones. Then we can have the contract completed for that phase 1. We can bring that phase 1 contract to an end. That is a severable contract, okay? Acceptance of part performance. Now, this could also bring a contract to an end if the other party accepts part performance, okay? So we have several parts for a contract. If not all the parts of the contracts have been completed, but some parts of the contract has been completed and the other parties also agree that, okay, although not all parts have been completed, I agree accepting, say, 3 parts, 5 parts, 4 parts of the contract completed, all right? Then that could also bring the contract to an end. part performance. And the payment again is quantum merit, as much as he has earned. Complete performance prevented. Sometimes the party would like to complete the entirety of the contract, but it is prevented from doing so. It's not possible to complete 100%. For example, if the party prevents proof performance, then payment must be made for the performance achieved. So if I ask you to quote an example for complete performance prevented, could you give me a simple example? Any suggestion? Now, for example, we have this room, okay? And say we have a cleaning contractor responsible for cleaning this room, okay? Cleaning the whole of this room, okay? But today, earlier, the contractor could only clean half of this room. The other half is not yet cleaned, okay? But if I'm the owner of this room, I tell the cleaner saying, okay, you need not clean the remaining half of this room because what? We are going to start our lecture. No time, okay? You are not allowed to come in again to clean the other half of the room, the remaining half of the room. Then the cleaning of the remaining half of the room is prevented by the owner, right? It may not be the wish of the cleaner, okay? So that could also bring the contract to an end. But as the owner has to pay the cleaner on the part completed, half. Understand? Right? That could happen in reality. Right? Again, payment should be made on a quantum merit basis. Agreement. Okay, maybe I better stop here, then allowing the remaining parts to be covered in the last part of this lecture. Okay, now as agreed, I will also allow you around 30 minutes to do the in-class activity. Now, here I would like to review. Now on Blackboard, have you checked my email, my message saying once your group has identified a case, right, then you have to post the name of the case in the discussion forum, right? Have you received this message? Yes? Okay, good. So that the other groups know that, because first come, first serve, right? So then what? Discussion. Okay, where's discussion? Here, discussion. So you click this one. Oh, okay. Now we have two posts. Okay. Click this one. I identify the cases. Okay, this one I posted because the that group emailed me. They have identified this case. I haven't checked whether this case has complied with the requirements yet, but I assume it is okay, right? But, and also this one, this is another case. Just posted 51 minutes ago. This one 5 days ago. So if you have you are another group, you have identified another case, you can post it somewhere here. Okay. All right. Then you can work on it, referring to my worksheet. Right. What you need to do. Okay. And you can take this 30 minutes or so to do it. So for those who haven't identified a case yet, please do so now. And remember the submission deadline, and you refer to the requirements, in-class activity, this one. Right, prepare to requirement here. Now we are here, 2nd of February. Okay, so I will continue with my lecture around 30 minutes later. Okay, just try to do it and discuss with your teammates to do it. And today I also issued the group list, right? Seminar grouping list, and also the presentation schedule for your seminar project. Okay. Seminar project, grouping. Seminar project, you know which group you are in and which case you need to handle and the presentation day and time. Okay? All right. So do the in-class activity now. And I will be back.